Big shout out to Tommy V in Michigan. He was on fire this morning.
Okay, thank you, Tommy V in Michigan. Yes, sir. If you share my prayers.
Tommy V's on. Yeah, we'll jump over there. How about that?
Where's right there. Stand. Yep. We got the camera. Say your full name. How you doing? Armand Hunter.
What's your full name, sir?
How you doing? My name is Deon Hunter.
Is it Demond Lamont Hunter, sir?
Yes, ma'am.
Thank you, sir. I'm Extradited Faster here on a criminal matter. Case number is 240-567-1501. Do you have an attorney? Go ahead, counsel.
Ryan Murad, PA 3665. I'm here, Mr. Demond Hunter. We waive the reading. Mr. Hunter stands mute. He's been advised of his rights.
Thank you. I'm going to enter plea of not guilty. Court dates are April 22nd, 2024, probable cause conference, followed by preliminary examination, April 29th, 2024. Both matters are for Judge Jefferson. Mr. Hunter, some bond conditions. One, you're not to possess any firearms or any other dangerous weapons. You're also not to go to the location of, I believe, I believe it's some sort of club. It's the Chicago Blues. You're not to go to that location while this case is pending. You are not to possess any firearms or any other dangerous weapons. You're not to have contact with these individuals: Arthur Bell, Ryan Page, Dennis Page, Lavon Robinson, and Curran Villanueva. When I say those individuals' names, sir, that means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. You understand that, sir? All the bond conditions. All right. Counsel Ragnan, go ahead, as to bond, please.
Well, Your Honor, we're asking for $1 million cash bond. No security, no tether, $1 million cash, 4 people shot, multiple times. This defendant, extreme danger to the public, to people, and to these victims. And I think $1 million is probably even not enough. We're asking for $1 million bond, Your Honor, cash.
Thank you. Go ahead, Counsel Moran.
Judge, I'd ask the court to be advised that Mr. Hunter is 32 years old, a life resident here in the state of Michigan. He has a stable residence with his girlfriend and their 2 children. Judge, he's gainfully employed as well. He's a driver. He's on call Monday through Sunday, 6 a.m. to 9 p.m. on call. He's actually in truck driver school now. He's also completed some college. I understand the allegations are serious and assaultive, but I would indicate he's obviously close to presumption of innocence, and we're very early in this investigation to really deem him a danger. He is charged under the habitual third offense notice statute. It looks like both convictions in that charging document are non-assaultive. I might ask the court for a confinement bond in this particular matter.
Thank you. Court has heard the representations of both sides. Court uses clear and convincing evidence standard when it entertains monetary bond. The charges 5 counts of assault with intent to murder, 5 individuals that were shot, that suffer injuries. This was at a location, started out allegedly, all these are allegations, started out where there was an argument between 2 sets of groups of people, and allegedly in this matter, it was Mr. Hunter, allegedly that pulled firearm, introduced the firearm, shot it, injured a number of people in this particular matter. This court does find that Mr. Hunter is a danger. We are going to go with $1 million cash, no surety, no 10%. It's going to be unaffordable. I think that's made to be unaffordable by Counsel Ragnan. And with that being said, Council Barat, I do believe it's unaffordable, correct?
Correct.
So that means he's gonna get a court date this Monday, April 15, 2024, 9 o'clock in front of Judge Mechanical, who's gonna review the bond amount and bond conditions.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, Mr. Honor, you can step aside.
Here,
State your name, sir.
Benitez Moore.
Thank you, Mr. Moore. I'm Magistrate John Faster. You're here on a criminal matter. Your case number is 822470273601, sir. You have an attorney. Go ahead, counsel.
Ryan Marat, PA 3665. On behalf of Mr. Bernadette Moore, we waive the formal reading. Mr. Moore stands mute. He's been advised of his constitutional rights.
Thank you, sir. I'm going to enter plea of not guilty. Court dates are April 24th, 2024. It's at 1:30 p.m., followed by preliminary examination, May 1st, 2024 at 1:30 p.m. Both matters at the Harper Woods District Courthouse. Mr. Moore, there are some bond conditions. One is you're not to possess firearms or any other dangerous weapons. Also, sir, while this case is pending, you're not to have contact with Melissa McLean. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. Do you understand that, sir?
Yes,
Understand the bond conditions? Okay.
yes.
All right. Let's see. Corporal Stagger,
Yes, Your Honor.
can you tell me, does Mr. Moore have any pending cases, any prior convictions?
Yes, Your Honor. So Mr. Moore was convicted of assault with intent to commit murder and felony firearm in June of 2015, where he actually pled guilty to those two felonies. Mr. Moore was paroled from prison on November 21st, 2013, exactly 1 month prior to this incident.
Okay.
And
You know
in
whether or
addition,
not-
Your Honor,
Okay, go ahead.
I'm sorry, Your Honor. In addition, I believe the complaint itself is severe enough for a remand, not to mention after this incident occurred, Your Honor, Mr. Moore fled the state and was arrested in Delaware by a fugitive team. So I believe he is both a safety risk to the community and a flight risk, Your Honor, and I would respectfully request a remand for those purposes.
When was he arrested in Delaware?
He was arrested, I believe, on March 5th, Your Honor, and he contested extradition, so we had to get a governor's warrant to get him extradited back to Michigan.
So it was March of this year?
Yes, Your Honor.
Okay, do you know whether or not there's a parole hold on him?
There is, Your Honor.
Okay. Council Barat, go ahead, Esteban, please.
Thank you, Judge. On behalf of Mr. Moore, I'd indicate that he's 29 years old, a life resident here in the state of Michigan. He's not employed at this time or recipient of government assistance. Judge, he indicates that obviously he's in crutches. He did undergo some physical trauma where he had to receive hospital treatment from. He indicates that he does have a stable residence here in the state of Michigan where he can stay with his mother. I would ask the court to consider a reasonable bond. I know that there's a parole detainer, and I'm not going to ask for a personal bond, but I would argue that he does have the right to a reasonable bond, Judge. This is a case from approximately, I would say, almost 4 months ago. I don't have anything that tells me that him and the complaining witness have had any assaultive issues between these two dates. For those reasons, I'd ask for a reasonable bond, if not cash bond, Judge, but I would ask the court to not remand Mr. Moore.
Well, first of all, the question is whether or not I can remand him. Under the court rule 6.106, I don't believe unless it's murder. This is not a murder case. Assault with intent to murder. There's treason. There's a few other charges. Hold on. Corporal Stagger.
Yes, Your Honor.
Does he have any other prior convictions? Assaultive?
No.
No, Your Honor.
Let me make sure what I have. Okay, in this matter, yes, okay. Reading of court rules 6.106, I believe, B, 1, 2 ayes, and, Council Barat, tell me if I'm wrong, where it says, that the court may deny pretrial release to a defendant charged with murder or treason or committing a violent felony, and at the time of the commission of the violent felony, the defendant was on probation, parole, or release pending trial for another violent felony, or.
Judge, can you cite that, the section that you're reading?
Okay. 6.106 B 1 A 2 ayes. I'm sorry. A 1A. Yeah, 1A 2 ayes.
106 1A. Yes, Your Honor, under this statute, that reads that at the time of the commission of the felony, the defendant was on probation or parole or release pending trial for another violent felony, that the court could remand him. But I just asked the court to consider my argument and give him a high cash bond in lieu of a remand, even though ultimately it's not going to make a difference. But this is a case from several months ago. And I would just argue that Mr. Moore should have a right to a reasonable bond.
Okay. I appreciate that, counsel. I just want to make sure whether or not I have the authority to do a remand status. I can do a monetary bond in this matter, but whether a remand status.
Yes, Judge.
Okay. And what I'm reading the allegations in the investigative report is that it is alleged that your client, Mr. Moore, at one point had a firearm, shot multiple times. The first shot missed, and then a couple more shots. It's either second or third shot that the complainant was shot, and allegedly she was shot hit her and her legs went numb. And the information is that whether or not the court is not aware whether or not Mr. Moore, he fled the state of the charges, but he was arrested by a fugitive team in that way, and he was brought. Okay, court having partially read the allegations in the investigative report, the court does find that Mr. Moore is a danger, and the court rule, Mr. Moore is going to be remanded. But counsel, you did make an argument for your client, a good argument. Thank you.
Thank you, Your Honor.
Thank you. That concludes the arraignment on Mr. Moore.
Thank you, Your Honor.
Okay, thank you. Have a good day, folks. Arbor Woods.
I'll get you that ibuprofen.
Okay. Dear Warren, you ready now?
Yes, Your Honor. We have Ms. Peterson here.
No problem. All right. Ms. Peterson, please say your full name.
Courtney Sherrill Peterson.
Thank you, ma'am. I'm magistrate judge there. Here on criminal matter, case number 822470765301, ma'am. You have defense counsel. Go ahead, counsel.
Ryan Murad, PA3665. I'm here with Ms. Courtney Peterson. We waive the formal reading. Ms. Peterson stands mute. She's been advised of her constitutional rights.
Thank you. I'm going to enter a plea of not guilty. Court dates are April 23rd, 2024, probable cause conference, followed by preliminary examination, April 30th, 2024. Both matters 9 o'clock in the Dearborn District Courthouse. Ms. Peterson, while this case is pending, there is no drinking of any alcoholic beverages. There is no driving of any automobiles, motorcycles, mini bikes, ATVs, golf carts. Do you understand that, ma'am?
Yes, ma'am.
Okay. Detective Nager,
Yes, Your Honor.
in reference to Ms. Peterson, I do believe, what I want to know is, does she have any pending cases?
According to the investigator's report, Your Honor, she does have some outstanding traffic warrants out of the city of Detroit, as well as an active warrant out of East Point for careless driving. There is a matter from the city of Warren from 2022 that does not appear to have been updated on her CCH, so I'm not sure the status of that. That case was for OWI.
But other than Warren, the other cases are just traffic matters, correct?
As far as I'm aware, yes, Your Honor.
Okay. Anything else I need to be aware of?
I don't believe so, Your Honor.
Thank you. All right, go ahead, Council Barak.
Judge, on behalf of Ms. Pearson, I'd argue that she's 26 years old. And other than that OWI misdemeanor from 2020, it's our position that she doesn't have any criminal convictions. Judge, she has a good job as a certified nurse assistant at Cornwall Hospital. She's been there for the last 8 months. She lives with her mother, her sister, her nieces and nephews. She's also her mother's caregiver. Your Honor, she indicates that she can't post a monetary bond, that she does meet the poverty guidelines. I would ask the court to consider personal bond, maybe with alcohol tether in this particular matter. Usually these offenses, despite, the seriousness of them, or maybe even the carelessness of the allegations, these aren't allegations that, is usually somebody intending to hurt another. That's usually just what happens after, alleged reckless decisions. And I think all of that can be rectified with an alcohol tether, because that ensures that no alcohol will be ingested by Ms. Peterson. I think the court could even go one step further here and do a no driving provision, and Ms. Peterson will have to Uber to work and spend a little extra money there. But ultimately, I'd ask the court not to send her over to the Wayne County Jail. She's 26 years old. She has a family that she lives with, a good job that she's been working at, and hopefully that this matter will see its lawful conclusion. I don't have a KPS history, particularly. I know that those traffic warrants mentioned by the police department are civil infractions, so they technically wouldn't necessarily amount to warrants. But nonetheless, I'd ask the court for personal bond, some sort of alcohol monitorization, and any other conditions seen fit by the court.
Okay. For the record, she does have a prior drink and drive conviction out of Ohio from 2020. After that, whether in Warren, there is no update, but I read the allegations in the investigator's report. It's not just leaving the scene. The allegations is that she was seen getting things from the motor vehicle, leaving, walking away from the scene.
Ma'am, don't say anything, okay? These are just the allegations of the police report. Don't make any statement.
Okay. That further, she was driving. Let me see, where was it? Might have missed it. Driving at minimum, or excuse me, prior to the crash, 58 in a 35 zone, okay, which is was approximately 23 miles, almost double, almost, not quite, but 23 miles over the posted speed limit of 35. She walked away from the scene. These are all allegations that the person that was hit, okay, had to be extradited or had to be taken out. I'm not exactly sure if how they had to get this victim, Bracy, out of the Sonic motor vehicle that they were in. Significant injuries, about a brain bleed, is my understanding. Okay. Kidney was punctured, severe internal bleeding. This is not, allegation is not simple fender bender, okay? This is serious injury to another individual in which Ms. Peterson allegedly, she drank, she drove. The court does find that using clear and convincing evidence standard, Ms. Peterson, that she is a danger. And counsel, if she had maybe a drinking and driving conviction maybe 10 years ago, this court would not take that so much into consideration. But she has from 2020, and then she has something, not 2022, but 2020, and then we have this. Okay, so in this matter, the court does find her a danger. Okay, and court is going to put $50,000, 10%. Alcohol tether.
Please, can I say
Wait.
something?
Wait, no, hold on, man, 1 second.
Go ahead, Council Barat.
Judge, I'm ultimately, I appreciate the court not doing at least a 10% bond and not a high cash bond here. But that $5,000 for a certified nurse assistant for only 8 months is not going to be postable at all. I think the court got it right, definitely, with the alcohol tether. I guess I'd ask the court to do sort of a trade-off, maybe even add a GPS or add home confinement or curfew to ensure that there's no driving. But that, or maybe even consider decreasing that 50,000, 10%, because ultimately, as much as I appreciate a 10% provision, it will be the same as a high cash bond for Ms. Peterson, as she can't afford to post that to get out. I think with the monitorization, you're guaranteeing there's no alcohol, and with the GPS, maybe even home confinement, you can guarantee that there's no driving. So there are non-cash means made available in this particular matter, Judge. And I just asked the court to use those instead of the cash means, even if the court sees that she may be a danger, because that danger is on the road. And there's other ways to prevent her from being on the road instead of keeping her in the Wayne County Jail. So I just asked the court to maybe consider that option before finalizing its decision.
Before we get to that, Detective Major, did I miss anything? Was there anything that you failed to tell me?
I take care of my mother. She needs me.
Not that I'm aware of, Your Honor.
She needs me. She needs me. Please. I'll be on the tether. I will not drive. I will not drink.
Let your attorney talk for you, please.
Council Barat? Okay. I still think that she's a danger.
Thanks.
Okay. But I am going to put her on a GPS tether along with the alcohol tether. I'm going to give her $50,000 bond. She's allowed to go to work.
And that's personal bond, right, Your Honor?
$50,000. Understand, if she's caught drinking, doesn't matter. She's caught breathalyzer, that, and it will be random that she has any alcohol. She's going to be spending her time in jail, because I'm sure that the judge in Dearborn is going to end up being, or circuit court will end up being, a high monetary bond.
You're absolutely correct, Your Honor. Thank you, Judge.
No problem.
We have nothing further.
Thank you.
I'll take a second. Personal bond. So if you screw up and you get arrested, that's what you're going to be next time.